Friends, you must be aware of the substantial hike in the fines imposed for traffic violations. The amendments have been brought about in the Motor Vehicles Act by the central government. Now we come to hear that the Kerala government is trying to bring out an ordinance by which the substantial hike that has been brought about in the fines could be brought down to tolerable limits. Now whether it be the new fines imposed or the rollback old fines, the rates at which it used to be imposed prior to the amendments, in both those cases, supposing we are caught up in a traffic violation offense, we may be in a dilemma as to whether to pay the fine directly to the officer concerned who had obviously caught us in our act, as it were, or to pay it in the concerned court of law. This video is trying to shed light on the authority before whom the fine ought to be paid and the powers of the authorities, the government authority in imposing fine and collecting it, and also details regarding that. I am Advocate Faisal. Under Section 200 of the Motor Vehicles Act provides, or rather gives power to the certain officers to compound offences, meaning settle offences, traffic violation offences. Now we shall examine who these officers are. According to the section, the assistant motor vehicle inspector of the motor vehicle department and officers above him have the power to compound offences. And in the traffic department, traffic police, the sub-inspector of police and officers above him are empowered to collect, or rather compound offences. And in the case of local police, it is the circle inspector of police and officers above him who have been given the power to compound offences. Now, supposing while riding a bike or a car in a public thoroughway, supposing we are flagged down by a police officer or a authority or a motor vehicle department inspector, and supposing that we are found short of having insurance for our vehicle, or even not having a license in our favor, or rather the license has lapsed out, obviously the officer has to take action. Now the question is, do we have to pay it before on the spot to the officer, or do we pay it to the court? Now, as per Section 200, the officer concerned has the power to compound offences. Now, supposing we say the person who is caught, supposing we say that we are not interested in compounding offence and that we shall pay whatever penalty there is for the offence before the concerned court, that should be sufficient for the officer, because once we say that to the officer concerned, obviously he will only collect the materials that we have, the whatever RC book details and our address and name, that he'll have to forward it to the concerned court for the appropriate court to take action, issue summons and make the accused pay fine whatever there is in the whatever fee or whatever fine is imposed for the offence. So there it stands at that. There's no necessity for a citizen to pay the fine amount to the officer concerned at that spot when he's caught. Most of the offences provided in the Motor Vehicles Act do come under the compounding section, namely section 200, like having no license, no registration, or driving while under the influence of liquor or intoxicating drug, and driving recklessly, causing danger to others on the road, so on and so forth. The table of offences in 200 are provided down below. In the year 2010, the Kerala High Court had passed a judgment on a case involving traffic violation. In that case, a scooter driver allegedly drove the scooter recklessly and dangerously, and a sub-inspector of police who had shown his hand, who had tried to flag down the scooter, the person didn't stop, and he went away. He drove away. Now, the question was whether the sub-inspector of police could issue summons for the accused, the scooter driver, to appear before the court of law. The court took the police to task because court said that the police didn't have any authority to issue a summon. That is within the exclusive jurisdiction of the court of law. The police took the defense that in the year 1972, circular was obviously issued by the executive magistrate, and therein powers have been devolved to the executive magistrate to consider offences, traffic violation offences. Court said that after 1972, the new criminal procedure code had come into effect, and the circulars were no longer in force. Court thereafter went ahead and advised the government, asking them to include all the compounding offences under a scheme where the parties concerned, the accused concerned, could be sent a notice or a summon informing the summons itself that they could set the fine amount being specified in the summons itself, that they could send the fine amount to the court concerned through post, by post loader or such other methods. So far, the government is not seen to have taken any action on that.